session, and today we are going to discuss with one important principle of the insurance contract is the contract of utmost good faith. We always say this, my friends, and it is also necessary in every insurance contract is that every contract of insurance should be commenced with or should be carried with the utmost good faith between the parties. And what is this utmost good faith? And why is this utmost good faith is necessary in respect of every insurance contract? If you just look down with the background of this, as how did this concept of utmost good faith developed, we see that at the very beginning of the insurance contract which was taken with, the contract was not considered to be, or it was not necessarily required to be, that there should be an utmost good faith. But in marine insurance, the very concept started with, and there it became an important factor that in every contract, the contract should be resulted out of an utmost good faith, that is between the parties again. When it is the scenario, how is this to be looked with? Friends, even contract act or the contract, insurance contract is one such commercial contract which we are going to enter into. And if you look at with the essence of this commercial contracts, caveat emptor was the principle which you are aware, which you have also studied under the General Contracts Act. Caveat emptor was the principle which was ruling under the commercial law, which means the buyer be aware. That is, when the buyer wants to purchase or enters into a contract or performs with any contract, it is his duty to be aware. It is duty to look that or scrutinize or look into all those things, whether that goods what he is purchasing or that contract which he is entering into is free from all those encumbrances. This is what is called for by the principles of caveat emptor when it comes to the commercial transaction. And this was there for several years. That is, till the passing of Misrepresentation Act 1967. After the enactment of this act in England, there was a light change or a deviation had taken place in respect of this business transaction. And it said that is, though it is a duty on the part of a purchaser or the contractee to take a reasonable care before entering into a contract, that is, before he buys the product or before he gets into the contract. But at the same time, it is also necessary that that person who is giving out the contract, that is giving out or performing the contract or entering into a contract, is equally liable to disclose all those inquisite reports of that which he is aware with. That is, he has to reveal all those facts which he is aware of, that of the contract which they are entering into. And this made the principle to look in a different manner. Or I can say you this, that is, because of the Misrepresentation Act 1967 was brought in, we see that this had a completely different footing and formed this as an exception to that of the principles of caveat emptor. So when we get into explaining as what exactly is this utmost good faith, in fact we can say like this, my friends, as being an exception because the parties are to be aware of what they are entering into and what they are contracting with. And by explaining this also we understand this. One of the nature of the insurance contract is inhalatory in nature. That is, it is also called as an inhalatory contract. That is the reason why it says that is, it may or it may not happen. So in that situation, what is your duty to do with? That is, what all that is there in your knowledge, what all that has come into your knowledge cannot be just going away or cannot be just hidden away by you. You have to disclose all those things that which is in your knowledge. That is, when an underwriter enters into a contract with you, when he underwrites the contract of insurance with you, When he comes to you and when he writes this, he may not be aware of anything about your background, or he may not be anything about your understanding as why the contract has been entered into. Or when you are taking the insurance policy, he may not be knowing that why you are availing an insurance policy. Of course, it is depending upon the kinds of policy. You would know that what kind of policy you are and what purpose you are doing and what are the areas it is covering with. But on the other side, the inner agenda of what one would have, whether it is an insurer or whether it is for that of the insured, he may not be knowing for what purpose or for what reason the contract is entered into. So in that circumstances, you should bring it to the knowledge of those underwriters that with all those material circumstances which you are aware of those facts. And at the same time, even the underwriter is also required to state that what all the things that is going to be covered by entering you into this contract. And that is what is called as utmost good faith. That is, each one, when you are required to disclose the information which is in your knowledge, that becomes the contract of utmost good faith. And this was being developed by the Latin term called as uberame fide. And what it calls is that to act honestly, just to act honestly. That is, when I enter into a contract, I should be enough to be honest while entering into a contract, and my intention should not be with an intention to deceive the opposite party. So this is a principle which is universally accepted. It is a great principle, I can say, universally accepted to all kinds of contract, But when it comes to the different other features of contract or other elements of contract, insurance contract, if you look in, we see that some of them may not be necessary in all kinds of insurance contracts. But when it comes to this, the first and foremost thing as an element to that of an insurance contract is it is necessary that every kind of contract which you are entering into, again I repeat, when I say contract, it is insurance contract that you are entering into shall be made by the utmost good faith, or it should be combined, or it should be carried with the utmost good faith. And what in law we look is that is whatever that is relating to that of the instances is contained should be revealed by you. And what utmost good faith calls is that it calls both the parties to observe this utmost good faith, and if not it is been made, then the contractor or contractee can avoid this contract. So that's made an important for us to understand that every contract of insurance which you are entering into should be carried with the utmost good faith, and if there is no utmost good faith, then the contract will not be effective. It becomes void at the option of the insurer, or it becomes voidable at the option of the insured. So that is the importance which lies in. Mind this, my friends. This is again a very important from the point of examination. I believe there could be two questions which could be asked in this. They may just go simply ask to you with explain the good faith and state the elements of good faith as an importance to that of the contract of insurance. One question could be of this. The other question could be is that is they may ask you within the invited commas there, stating that a contract of insurance is a contract of utmost good faith, discuss. So these two questions are very expected from the point of examination. So we should understand completely, thoroughly on this part of the area. And as I said to you just now, it is principally accepted. That is all through the world. That is in the entire globe, it is said that every contract of which you are entering into, the contract of insurance which you are entering into, should be the contract of utmost good faith. That is, this principle calls for both the parties. That is, when they sign for the contract or when they enter into a contract by signing together, that they should have exercised with good faith to each other. That is what that each of the parties should have exercised honestly. That is, insurers, it says the insurer must provide all those complete, correct, clear information as to the subject matter. In the like manner, the insured is also bound to disclose all those information without concealing anything which would influence that of the contract which you are entering into should be exposed, or it should be opened by the insured to the insurer, which would have an influence on that of the insurance contract. And this is applied to all the terms of contract. As I said, it is applied to all the terms, whether it is a fire, whether it is a marine, whether it is a life. Maybe the time might be different, that I'll be telling you a while later. The time may be different, but what is required here is that it says on every contract which you are entering into, all those contracts of insurance should have to be applied, and it is applied with the principle of this utmost good faith. That is, if any person that is insured, when is willingly fails to disclose or fails to surrender the insurance completely, then such, because of the information what he has been hidden with as to the subject matter of contract, you can become, or the contract may become voidable on that of the person because of the reason. Again I say, if you have failed to give out all the particulars, if you have failed or hidden certain particulars, or if you have falsified certain particulars or information, or if you have presented the information but that presentation of information is wrong, or it is in a wrongly manner it is been made out with, then in all such cases, my friends, we shall see that the principles of insurance contract is applied and results out that the contract will be unvoidable in nature. So from this scenario, if you look down, my friends, we shall say this, that is, the rule of caveat emptor, though it was ruling for several years, but now the application of this rule of caveat emptor has become a less importance. And I can also say you like this, my friends, that is, the rule of caveat emptor has gave away for its other development, and this contract of uberami fide has stood to be as an exception to that of the principles of caveat emptor. So that the caveat emptor, that is the buyer, when he purchases the goods or when he enters into a contract, it is a bounded duty to look out and to verify whether the goods or whether the contract which he is entering into is fit to be entered into a contract or not. One hand it says, but the other hand equally it says that is, if those things which are not openly exposed, see, if I am a man who wants to take up an health insurance, probably the person that is the insurer will not be knowing that what is the illness that I am having inside my body. That is, it is my duty. See, if it is openly exposed, if it can be easily assessed by any other person, if it is easily viewable by any other person, the defect comes latent on the part of a person, then fine, doesn't make any sense. But when those facts which cannot be seen, which cannot be disclosed or easily can be made out, and it has to be made out only by the disclosure of you, then such has to be informed by you, it has to be stated by you, and it has to be disclosed by you. And that is what the honesty calls for, and that is what the utmost good faith calls for. That is, when you are entering into a contract, you should enter into a contract with an honesty, and both the parties should act in good faith to the benefit of each other. That is the principle, because the very aspect of principle is that is, it says that is one in case of loss, that is among yourself, that is maybe I might be 100,000 or 2,000 or 2 lakhs or 20 crores, whatever the number of persons that might be there. But what we are undertaking, that is, in case of difficulty of any one of the member or 2 or more member of in the group, then we would be compensating to each other. So when I say that we will be compensating to each other, when we say that I am going to indemnify that of each other, I would mean to say that I would be acting in the interest of each other. When we are acting in the interest of each other, vice versa calls for an acting of utmost good faith. That is, to act by me in the good faith to each other. That is the principle what it calls upon with. And how does this work with? How does this principles of utmost good faith work with? In fact, I can say this, my friends, what are the elements of this utmost good faith? Or I can also say in this way, what are the components of this utmost good faith? See, there are 3 components, my friends. One is, it calls for a representation by you. It calls for the active concealment by you, that is disclosure. The third one, it speaks with the warranty. When I speak to you with what is this representation, the first one is the representation. In fact, it says that when the parties come together to enter into a contract, both the parties I'm speaking, when the parties comes together to enter into a contract, it is the duty on the part of both the parties to give out all those relevant information. And in giving a relevant information, it is also a duty on the part of a person to make it honestly, providing all those figures and all those pictures of which the premium and coverage is going to be taken with, subject to few limitations, of course we have. So it is my duty. How am I representing to you with? It is my duty. When I represent to each other with each other, that is, each one is representing to each other, they should act honestly. They should act without having any concealment in themselves. That is what the utmost good faith calls upon with. That is, when I enter into a contract and I am required to pay a premium on that of the insurance contract, and when I am required to pay a premium on that of the insurance contract for which the insurer is undertaking your risk, then each one of us should state or disclose all those things which would influence on the premium or which would influence on the risk what the insurance is undergoing to take with you. So it says that is the premium figures and the coverage limitation should be openly made out by both the parties as to each other. A simple example I can give you is, that is, suppose say I am taking a car insurance, and when I go for taking a car insurance, what is that I am required to do? What is that I am required to disclose is that I should disclose that whether there was a prior accident to that of the car, or whether that there was a trafficking tickets was been happened to my car, or trafficking tickets, that is any defaults has been come across with. These things has to be addressed by me before I could take a car insurance. So the duty is there on the part of the insured to disclose upon with. Likewise, if you take an health insurance for that matter, in case of health insurance, I am required to go speak about that what is my health, how is my health. I may be knowing, there are certain facts which I would be knowing. Maybe sometimes the one form of recognizing the age of a person is your SLC mass card. So the SLC mass card or secondary school living certificate mass card or 10th certificate could disclose the age of a person, but the internal issues in cases of health certificate, whether I had been with any diseases or whether I have been treated with any of the ailment, or all these things that I have to disclose for myself. So the duty is posed upon me to disclose all such facts before the insurer. So both are reciprocally required to act each other, disclosing all those information which is necessarily to be required with. That's what it says. When I say representation speaks to with the material facts. What becomes a material fact? See, material facts sometimes vary with the facts of the case also. Depending upon the circumstances of the case, it may vary from one area to that of the another area. But how does we recognize? The general recognition, what would be a material facts? What should be the disclosure of the material facts? Say for example like this, if I am taking a life insurance or a health policy, the medical history of a person, the hereditary illness, if that would be always there with that of my family members, the hereditary illness, habits of which I have it, or hobbies which I am always in, or the income details, age of a person, or even where the existing policies if I am having to with. These facts becomes a material facts from the part of the insured in case of LIC, that is life insurance policies, or in cases of health insurance policies. But if the same were to be a fire policy, then the material which I am to disclose with is different from that of the life insurance. Like when I go with the fire insurance, I would be speaking that how is the product that is being constructed, what is the usage of that product, usage of that the goods which I am taking with, age of the building if it is a immovable property, nature of the goods which I am going to be given to with or which I am going to have my insurance, these factors becomes an important. Whether it is a perishable or non-perishable, these factors becomes an important criteria which I am to be disclosed with. And the same thing if you look at with the marine insurance, it speaks that is you are required to give out the detail of the goods, then you are required to give out the method of packing, the area of which it is going to be transported. All this becomes an important factor on your part to be disclosed with. Likewise, if you take a motor policy, friends, motor policy, that is in case of motor policy, we see description of vehicle should be given, date of purchase of that vehicle should be given, details of the driver who is driving the vehicle should also be given along with this. So these factors becomes an important one to be disclosed by the insured to the insurer. So it calls that is when I enter into an insurance contract, it becomes necessary for me that I should provide all those information which would have an influence on that of the contract. That is why in a simple word it says that is all those material facts which is in my knowledge has to be provided for you. That is the material facts, in a simple word to say where it is those facts which influences the judgment of the parties. I repeat this, the material facts are those facts which would influence the judgment of each of the parties. That facts, that is which influences the parties, should be disclosed by you. If there is a non-disclosure on your part, then you would have a right of avoidance on that of the insurance what you are taking to with. So the first one calls, that is the first element or the component of insurance that is utmost good faith calls for the representation, that too a honest representation from your part. The second one is the concealment. Friends, this is again somewhat closely related to that of the misrepresentation. That is, it speaks something with the intentional omission on your part in its disclosure. Again, I would like to say that is, if you are hiding certain information or if you are concealing certain information, then that concealment of an information where it forms to be a material in nature, then the insurance can be avoided by you. That is, the insurer can treat the contract as void and deny the payment of which the claim you have against the insurance company on the occurrences of risk on your part. So when it says that, the second important, as I then said, is that there should be no concealment by you with respect to that of the material fact. Concealment could be with those. See, the question of concealment would not come there, sorry here for that. That is, the concealment is only when it is in your knowledge. When if it is not in your knowledge, then there is no question of concealment. So what it calls here is that when you enter into a contract, what all that is there in your knowledge, what all that you know about with the contract which you are entering into has to be disclosed with the subject matter of the contract which you are entering into. I would like to take a very interesting case here. That is, in case of LIC versus Shakuntala Bai's case. A very interesting case and a noteworthy case also I can see, where the Supreme Court came out saying that when the insurance contract is taken with, the party should act fairly and honestly to each other, and this honestly to each other should be assessed by each other, and only after which they should explain it properly and then sign to that of the contract. This is what the observation that the Supreme Court makes in. And the facts of the case was something like this, my friends. A very beautiful case for that matter. See, a person takes up an health insurance here. It takes up an health insurance, and by taking an health insurance, maybe on some day he takes an health insurance, and while taking an health insurance, he never speaks anything. Insurance, the medical certificate was also being provided by this person, and insurance was being carried with. But just a month back or so, before after having taken an insurance, the person had suffered with an indigestion. So when he had suffered with some indigestion, he runs down to that of the Ayurvedic practitioner, and he shows them, and as a result of that, the Ayurvedic doctor gives him some churna to take with, and he takes that churna, and thereby so to some extent it was clear. But after a few days of this, he was infected with the jaundice, the disease of jaundice, and the jaundice went to a severe effect, and as a result of that, he died. And when he died, the wife of this insured comes up with the plea saying that for the claim, or for the honoring of the claim, that what the insurance had taken with, for the life insurance. Now the question was this, that whether the company is liable to pay upon with, because the company had already refused, saying that there was no enough disclosure, and there was no disclosure of the facts of which he had taken an insurance, that is, sorry, which he had taken a treatment from that of the Ayurvedic doctor. Here the court, going down to this matter, it said that the act before what has happened, it was just a small disease, and it was just where indigestion was being caused, and that has no effect on that of the insurance what is taking. And the court observed saying this, that is, when the insured, while taking the insurance of the life insurance, he was clean and cogent with which is taking, and this instance, that is falling of illness because of indigestion, he had gone to Ayurvedic doctor taking churna, is no way concerned with that of the claim what is being made. So it said that it is not a relevant fact, so that the company cannot refuse of denying the payment of which his wife is entitled to have on the death of her husband. So what we say is that, now this is a negative in nature. The case is, what I spoke to you is a negative for that of the subject what I am speaking, which says like this, that is, I am required to conceal those facts. I am required to disclose all those facts, but what disclosure that I am required to make is, I am required to make that disclosure which is necessarily required to that of the contract, or I can say you in this way, which would necessarily influence you on that of the contract. So that is what is importantly required by you to be disclosed upon with. So this is one such area which says that is, when I enter into a contract, it calls that most good faith calls for an element saying that you are required to state all those facts which you are in knowledge, and you cannot go with the concealment of any facts which would influence on the contract which you are entering into. And the third component of this is the warranties. See, warranty is nothing but, in a simple word, if I am to go with, it is a continuing guarantee. Why I say is this, see, that is, when I enter into a contract of utmost good faith, that is, when I enter into a contract of insurance, undoubtedly we say that this contract of insurance is a contract of utmost good faith, which would be carried with a warranty. That is, it is a continuing guarantee, wherein it requires that the insurance applicant to do certain thing during the course of his time, during the period of his requirement, during the contract which is in existence, which says like this, my friends, that is, I cannot do such act which would cause more risk to that of the insurer in case of that he has undertaken the risk. A simple example I can give you here is this. Suppose, say, if I have taken an health insurance, having taken an health insurance stating that I am fit and fine and my health is in good condition, and I have taken an insurance for more than 1 year, or for the period continuously for the period of 10 years, depending upon what. Now, having taken an insurance, can I hack to the whims of my own? Can I become an alcoholic? Can I become a drug addict? Can I involve in all those unlawful or untoward acts? No, because that is not called for in the insurance. See, when I enter into a contract, there is a duty which is being owed on me, that I should act in such a way that should not have any bad influence on the contract which I have entered into. So if I have taken an insurance for my car, saying that yes, okay, I have an insurance to my car, can I go rash and negligently driving my vehicle? No, because the utmost good faith is continuous for all the period of which the contract is in existence. So what I can say you is that the contract of utmost good faith is necessarily required to be there throughout the contract of which you are there in the insurance contract. That is the entire period of insurance contract. We shall see that the contract should be, that is utmost good faith should be there. That's what we say. And I would like to say one another thing here is that this principles of insurance utmost good faith was largely, I can say, vehemently said by Lord Mansfield in case of Carter versus Boham's case, where the case, in this case, they said that is, I mean, they recognized the first time that the utmost good faith should be necessary in all those of the insurance contract. And I would like to take one another case here is that T and Das versus Oriental Insurance Company and others. It was a consumer case. I repeat this. T and Das versus Oriental Insurance Company and others. Of course, this was again with the case of non-disclosure clause. So in this case, it so happened like a person had taken an insurance for his motor vehicle on a condition that, or with a statement that, I don't say condition, on the statement that it is a private vehicle and owned for personal use. And accordingly, the insurance was being granted to that, or it was being given an insurance to this vehicle. But after a few days later, somebody approaches to this person and takes this vehicle on hire and said that within relevant time that I would be giving you back this vehicle. And so the vehicle was taken for the hire and the position was also given to him. It was parted with. Then when it was parted with, the same was not being intimated by the insured to the insurer regarding with the hiring of vehicle. And when the vehicle was parted, the vehicle met with an accident. Results was that there was a risk involved. The result was that some ailment had taken place, injury was involved, and damages was being caused to the property as usually. And because of the damage that has been caused, the person comes before the insurance company seeking for the compensation which is liable to be paid on it. The company discloses for the same, saying that, or refuses to pay the compensation for the same, for the reason that there was no enough disclosure. The matter goes before the court. Undoubtedly, it said that the first agreement what had been entered between the parties was that is the vehicle, the use of vehicle is only for the personal purpose, and the vehicle, parting of vehicle on hire was not within the ambit of the contract, and that was not being made a statement here, and that was not being disclosed here. So hence it said that the defense taken up by the insurance company saying that there was no enough disclosure on the part of a company that with respect to the hiring of vehicle had resulted in saying that the contract is not effective, and accordingly the court dismissed the matter for the reason of want of disclosure. So what we understand here is this, my friends. There shall be enough disclosure with all those material facts which is there within your knowledge. This is what is called for. This is what is required to be made by you in respect of that of the contract which is required. Which says that is whenever when the contract is entered into, you should enter into such way that you are going to disclose all those information which is necessarily required by you. So what disclosure has to be made? To what extent disclosure has to be made is one such area which you have to look in. We shall look at that how disclosure, when disclosures are also going to be exempted in giving to. So we'll go with what is disclosure, when disclosure is going to be made or required to be made upon with. Now, disclosure is required to be made by the person. What is this disclosure has to be made? What disclosure has to be made? When a disclosure has to be made, with what issues a disclosure has to be made, this becomes an important. This becomes an important. We understand this as what disclosure has to be made. We shall say that the disclosure of all those material facts which is necessary, which would influence the judgment of each of the parties in respect of entering into a contract. With respect to those facts, disclosure has to be made. But when a disclosure is required to be made, see, generally we say this, every disclosure has to be made before the contract is concluded, which says that what a person would know with all those material circumstances, or what an assured knows with all those material circumstances or material statements or material facts which is in his knowledge. Likewise, even in case of the insurer, what all that the insurer knows, to what all the extent the contract would be made applicable, to all those facts, it is necessary that both the parties should disclose to that of the insurance what they are entering into. That is, before the conclusion, that is when before the parties signing to the contract, putting their attestation to that of the contract of insurance, both the parties should disclose all those material facts which are being known to them or which are aware. And it is generally presumed by everyone that the assured is deemed to know every circumstances of the contract which is entering into, as in an ordinary course of business. So it is also at the same time understood that it is the duty on the part of an insured to give out all those information or reveal out all those information which is in his knowledge, or which he ought to have known in his knowledge. Because sometimes law presumes that the person had a knowledge in him. Suppose, say, if all my forefathers have died out of an heart attack, then then I would have definitely a knowledge, because my family history would state that. My family statement would state that. My family members would have revealed me this. That is, all my forefathers, or maybe if not the forefathers, at least my father, my grandfather, would that they have how they have died with, I'll be definitely knowing with. So in that case, in an exception or always there, I'm not on that area. But generally I'm speaking, in a general sense I'm speaking, I would be knowing that it is my duty to reveal that. So that's what law presumes, that what the person ought to have known, the knowledge in him has to be relieved by him or revealed by him before the conclusion of the contract. And it says that where if a person fails to reveal such statement or reveal out all those information which he has in his knowledge, then the insurer shall have a right of avoidance of contract. And because of the non-disclosure, because of the concealment of the facts what has been stated, if the insurer gives a right, or when it paves a way for a right of the avoidance of contract, then such right what the insurer is exercising upon is said to be called as right of avoidance. I repeat, such right of avoidance of contract is said to be called as right of avoidance within the brackets I'm speaking. So the right of avoidance is always exercised by the insurer in case of an concealment made by the insured again to the insurer. So this is the first criteria which it looks one. So the right of avoidance can be made for the want of utmost good faith. The second thing which we also see is that it says that disclosure should be made with every circumstances which are material in nature. That is, which would influence for the fixing of premium. Suppose say, if I was suffering from dyslexia and or any other form of disease which I would state in, then it is my duty to give out those information, because if I don't give the information, then maybe the risk would be more on the part of an insurance company, and because of the risk is more, the premium would also become more. As I then said to you in my discussion, that any statement or any facts which would influence the judgment or which would increase the risk of the insurer or which would increase the premium of a person which is payable on that of the contract which he has entered into, all those things forms to be a material fact on the part of a person, and all those facts has to be disclosed by the person. That is, those facts or those material facts which would have an influence on the premium, those facts which would always have an influence or which also have an influence on that of the risk what the company is going to undertake with those facts you are necessarily required to be disclosed with. And this disclosure is said to be called as materiality and inducement. We call it as materiality and inducement. That is, those facts which would induce the mind of a person or which would have an influence on the mind of a person, those facts which are considered to be as a material should be disclosed by you in the course of contract which you are entering into. So these are the two prima facie I can say, or I can also say you in this way, these two are the primary requirement in the act of disclosure or as an element of disclosure. You have to disclose these two criteria very importantly. But the question is this, as a third phase, if you are looking to what material facts I am to disclose, it only says that is on an inquiry you have to disclose all those material facts of which you know. But what material facts need not have to be stated by you? What is the information that is not required to be given by you, even you are aware of the fact? That's what we say, what is not to be disclosed. Friends, when we say what is not to be disclosed, very briefly I'll be speaking to you with, that is any circumstances which diminishes the risk, which lessens out the risk, need not have to be stated by you. That is, you need not have to disclose on those facts. Or the second one, it is something like there are circumstances which the insurer is presumed to know about the facts or about the contract, about the facet of facts in respect of the contract, where the insurer himself is going to be known. That is, you would be giving your document, say the same example of SLC mass card or 10th certificate, where the age would be certified there or clarified there, then you need not have to state about that, because there is no need of requiring a disclosure because the document itself speaks for you. Or the services of your employment itself would speaks to you that what you are, what is the status of you. So in those areas you need not have to make your specific disclosure. That's what it says, where the insurer presumes to know that certain facts which is already in his knowledge, those things need not have to be disclosed by you. Or we shall also say that is those facts which are being waived by the insurer himself. That is, he has given up to take up those information. He has just left out, or he has just given up, or he has just ignored of having taken those information from you, need not have to be stated by you. So it says that is, if these circumstances are there, you are left free to not to disclose with. Likewise also we say that those circumstances are those instances which are a superfluous in nature, that is, which is excess to the need of the contract, it need not have to be stated by you. or it is also we say that those circumstances or those set of facts which are not material to that of the contract which you are now entering into. That is, it has no relevance, or it has no greater influence on that of the contract which you are entering into. Those facts also need not have to be stated by you. So when at one point we can say that there are certain facts which are required to be disclosed by you. There are certain exceptions which also says which need not have to be disclosed by you. But only thing what all this says with the crux of this, what all this says is that you are required to state, you are required to disclose or reveal to that of the insurer the facts of which you know and which it is in your knowledge, and those facts are material in nature. If the facts are not material in nature, or those facts which would have no greater significance on that of the contract which you are entering into, then those facts need not have to be stated by you. Those facts can be ignored by you, and that would have no effect on that of the contract what you have entered into. The same wise, if I am to go with, suppose say if an agent comes to you, like insurance agent comes to you, how can a contract be effected? How far disclosure has to be made in this area? See, when an agent approaches you on behalf of a company, and if you are revealing certain information to that of the agent, then again it calls for certain duty on you. That is, as an agent is been acting on behalf of the insurance company, that is on behalf of the insurer, and the agent must disclose with all those particulars of what the insurer can give it to you. That is, the material circumstances or the material facts which the agent knows for himself is said to be or is deemed to be known to that of the company too, or vice versa also you can address with. That is, those information which is required to be revealed by the company is something, an information which the agent is giving himself on behalf of the company. So every such material circumstances which you know to himself are deemed to be known to the agent, and that agent should in every circumstance, in ordinary course of his business, he has to bring it to know it to the knowledge of the insured also. That is, what ought to have been known by an insured is said to have been disclosed to that of the insured. This is one criteria we look in case of an agent, where a contract is entered through an agent. Likewise also we see every material facts which the assured is bound to disclose, that is assured in the sense which the insured is bound to disclose, unless it carries in his knowledge and it is too late onto the circumstances to be communicated with to the agent, has to be disclosed by him. Suppose say an agent comes to me today. When an agent comes to me today, I might have spoken to him, I might have revealed all those things. But tomorrow, or maybe after 3 days or 5 days, if I am inflicted with some other diseases, which I might not have disclosed to that of an agent, then those disclosure need not have to be said. What it calls is that from the part of the insured, that is assured, is required to state that information what is necessarily in his knowledge. That is, at that time, what all he know or what ought to have been known by him should have been revealed by him in respect of those contracts. This is what it calls upon with, and it is a well settled principle, my friends, under the contract. At most good faith is something, my friends, where both the contracting parties are placed on a special duty. I repeat this, both the parties are placed on the special duty towards each other, and what the duty is that they have to make the fullest disclosure of all those material facts which is there in their knowledge. That's why we say the utmost good faith is in a way is imposed a duty upon you to disclose all those facts which is in your knowledge. In a way, I can also say you that the good faith also parallelly carries a duty on your part to speak upon, to give an information, to disclose upon certain things which both the parties are required to know upon with. So in the way of that duty, it says that, or in exercising of this duty, it says that there shall be a disclosure, and that disclosure should be on all material facts which is known or it is going to be imputed. But if there is a non-disclosure, or if there is a concealment of any such fact, then merely because there is a concealment or non-disclosure of a fact would not in itself make the contract as void. I repeat this. Mere non-disclosure of certain facts or mere concealment of certain facts in itself will not make the contract as void. See, if that concealment is only a negative duty, if it has no positive duty in itself, then that will not have any relevance. Or I can, in a straighter way, without adding any color to that, I can say you, if you want to say you with this, is that if the information what I am concealed with has no greater influence on the contract of what you are entering into, then that need not have to be stated by me. I need not have to state upon to you. So the duty to disclose is confined to only to that of the material facts and not to the other thing. Even if there is a omission of disclosure by me, where if that disclosure is non-disclosure is not a factor in nature, which has no influence to that of your contract, then it has no effect and it cannot be even taken by the insurance company as a ground for its non-disclosure in case of honoring your contract. So it says that the duty, or what it calls under the good faith, is extended only to the material fact, and if there is a failure to disclose any of such fact, that maybe the disclosure might be sometimes willful, inadvertence, or it could be an erroneous belief, or if I am feeling that it is not, whether it is a question is of whether it is a material or not. If on these facts, if I have not stated the certain circumstances, or under certain circumstances if I have not stated to with, then that would not hamper to the contract what you have entered into. Again, I would like to take one beautiful case here. That is in case of Rohini Nandan versus Ocean Accident and Guarantee Corporation. Rohini Nandan versus Ocean Accident Guarantee Corporation. Again, it was a case before the Supreme Court. See, here at the lowest court I am speaking, the plaintiff, he was designated as plaintiff in the lowest court, not in the Supreme Court I am to go with. The plaintiff had insured his property, that is first floor of his property, against fire and burglary. That is in respect of all those furniture, household goods, and also the personal goods like jewels and others was being the subject of the insurance. And he had taken the insurance for the first floor of the building somewhere on the 1st July. On 5th August of the same year, a burglary was carried and several of the goods was lost in his house. And as a result of his losing of his property, he claims for honoring of the claim of in which he had an insurance on those goods and sought the company to indemnify the loss what has been caused to him. But the insurance company refused to give or honor upon the claim of this insurer on the ground saying that this person, while taking an insurance, had suppressed the fact of burglary which had taken in the ground floor of the same property. Now, this question was being brought before the court on the refusal by the insurance company. The court, making an observation, it said that true, no doubt there was a burglary much before that of the person taking an insurance that was in the ground floor. And the burglary that has taken in the ground floor and disclosing that of the information what has been taken on the ground floor, whether constitute a material fact or not. And there the court, while deciding upon with this, it said that is the burglary which had taken in the ground floor had no relevance to that of the burglary the fire and burglary for which the insurer has taken in the first floor. It was not the same house. It was not the same with the persons. See, what is that the information that is the insured is required, or the assured is required to give, is that the assured is required to give the information or disclose the information which is concerning to the party, which has an influence to that of the property of him. If suppose if some theft is being carried in my neighbor's house yesterday, though there might be a chances of the same theft could be carried in my house today, but it is only a chance. It is only a chance. That is contingency. It is just a wagering. So, in that scenario, the court took out and said that is, this non-disclosure of the fact that there was a burglary in the ground floor few days before or few months before of the person taking an insurance is not a material fact which a person is required to be disclosed. And there the court said that is, bearing this in mind, it ordered the court, that is the insurer, to pay as which they have contracted with. So what is called here is that, by this case, is that, see, it says that the insured is required to disclose all those facts, all those material facts which is in his knowledge or which is happened to be knowing with, or it calls for that to give out all those information, to reveal out all those information which he ought to have known. There is a lot of difference between which he know or which he ought to have known. Ought to have known is something, a constructive imputation on the part of a person. Though I may not be having a knowledge, literally I may not be having a knowledge, but the law presumes that you should have a knowledge in that scenario. And the law presumes that you had a knowledge, and even having a knowledge, if you have failed to disclose, then you are liable. That's what it says. What law looks is that you should give out a knowledge of what you all know with, or you should give out all those information, disclose all those information which ought to have been known by you. I cannot negligently sit on my lap, or I cannot negligently sit on my bed and feel free that now I don't want to disclose. It is my duty to know what is happening. Maybe to some extent there, be aware of your rights comes in. That is the reason why it says that you should be giving all those information. And what law says here is this. See, law excuses you. I'm quietly contradicting to the one statement which you all know here. That is what I'm trying to say you here. Law may ignore the facts which is not in your knowledge. Or I can put you in this sense. Ignorance of facts is excusable. Ignorance of facts. Even the law says this. Ignorance of fact is excusable. But ignorance of material facts is not excusable. Where there we say ignorance of facts is excusable, ignorance of law is not excusable, we say. But here we say that ignorance of fact is excusable. But ignorance of a material fact is not excusable, and all those material facts should be provided by you in case of the contract what you are entered into. There shall be no breach of good faith by you by disclosing certain material facts. That is what is called upon with. And the same thing here it also says, it also extends, the same principles is also extended to the agent. And it says that when an agent enters into a contract, or if you are entering into a contract with any of the agent, could be an agent of you, the agent of the assured, or it could be by the agent of the insurer. Whatever the agent it is, the same principle is applied to it, but one small exception. Because see, in LIC, especially in LIC policies, we come across that where a person has not communicated with the illness of what he is having with, but still if he has punctually or regularly paid the 2 years of premium in spite of those diseases which he is having and not revealed that disease, then the insurance company cannot take back the contract on the reason of not disclosure. So what we say is that except that of the life insurance policies, because again I am repeating, in life insurance policy, even where there is a non-disclosure of the information, but if I have survived for 2 years with the same disease, and after the lapse of the 2 years, that is having paid the 2 premiums on it, this non-disclosure cannot be a ground for the company, that is life insurance company, to take as a ground of defense in case of honoring the claim. But except of this, it says that is in all other cases, it says it is my duty to give out the information to the person, that is to disclose all those relevant information of the material facts which I am aware with. So if I'm going to do a marine products, like what is the cargo, what is the building, what is the insurance that I'm taking, to what time I'm taking, all this has to be given to you, and that has to be audited properly. This is what it is called for with. Or otherwise, if you don't relieve, then there can be always be a right of avoidance by that of the insurance company. And another requirement which also calls in case of the disclosure to be made is that, see, this disclosure applies only in case of negotiation proceedings. I repeat this. This disclosure is made only in case of negotiation proceedings, that is at the time of formation of contract. There are several insurances which are mandatory in nature, which are compulsory in nature, even without your knowledge you go with. So in that case, is it necessary for you to reveal certain information to that of the company? Says no. A simple example I'll give you is this. See, suppose if I am traveling by air, traveling by plane. Now, once when a person is traveling by plane, or even now it has been extended even to that of our government buses also. If I am traveling by plane or bus, knowingly or unknowingly, there is a premium deducted by from that of your payment has towards the insurance. That is in case of any death, or in case of any loss, or in case of an accident, the person should be suitably compensated. Now, when a person is going to be suitably compensated for the premium that what you have been paid, and which you are also sometimes unaware of that there is an insurance on your part, this works. This says that a disclosure need not be made by you, or under such circumstances there need not be any disclosure required to be made by you. So when the duty of good faith calls upon you to disclose the facts, is that only when the facts are being carried through the terms of negotiation, that is where the parties comes together, negotiate to each other, and thereby enter into a contract. But where there is no contract, it's where there is no negotiation. Contract is there where there is no a contract taken place by way of negotiation, or if the contract has taken something which is compulsory in nature without your knowledge, or without the sense of it. Say for unlike you, if you have a gas cylinder, now in WhatsApp we would be coming across that you are entitled to such amount of insurance or premium which is being insured under the company. If in case of any damages or so from that of the gas agency, you are entitled to such sum of money from so and so company. You would not be knowing itself. So in that cases where there's the question of disclosure comes. So the person cannot say that the disclosure has to be made. So in that way, my friends, we shall say that the disclosure is to be made only with those things which you have a knowledge. If you don't have a knowledge, then it is not necessary. Likewise, I will take you one case here. Ratanlal versus Metropolitan Insurance Company. In this company, a person takes a life insurance, that is for his health, not life insurance, it is an health insurance it takes, and a proposal was being filled on 24th January. The premium was also being paid to that. On 26th March, the company accepted with, and the same was being communicated on 27th March. I repeat this, that is, proposal was entered on 23rd January. The premium was being paid on it. The company also accepted this premium on 26th March, and the same was being communicated on 27th March. But unfortunately, on 28th March, the person comes to know that he has a disease. On 28th March, just after the day where the communication is completed. There was an he just goes to a doctor for a small checkup, a routine checkup, small checkup, and the doctor checks him and comes to say that there is no such thing, and he has been allowed to take with some what is that some a simple medicines was allowed to be taken with, and he takes and keeps quiet. But few days later it dies. The question comes up before the court is that there was no enough disclosure made by the person. There was a absence of duty to disclose the material facts which it was required to be made. There the court going to this matter, it said that, see, the duty to the disclosure shall be made only with respect to that person when it is called, when that was in knowledge when the negotiation has taken place. If the facts which was not in knowledge at the time of negotiation, then the duty is not casted upon the person to disclose upon with. So such duty cannot be exercised upon, and accordingly the court said that it is the duty that is as the insured was protected with, the insurance company is liable to pay upon with. So what we understand here is that is the duty is always there to the insured to disclose all those facts which is in his knowledge, which he has in his knowledge at the time of negotiation. But it again says with the duty of disclosure shall be made by both the insurer and insured when the insurer and insured asked with a specific question. Though it may not be necessary sometimes, but still we say that is when the insured enters into a contract, both insurer and insurer enters into a contract, then in such cases, my friends, it says that he is required to make an explanation, he is required to disclose such information, even though sometimes it may not be necessary, but is required to give out those information when there is a specific question is made out on that. So the duty to disclose is always there on the part of the insurer as well as the insured. And it gives out an exception, as I was saying you, what can be exempted. See, as far as an exemption is concerned, the duty of disclosure is not required to be made when the insurer or the insured himself is not aware upon the fact, or the second one, as I then said, the facts which are not within the knowledge of the insurer himself, or where the facts which are within the information which the insurer himself has weighed such information, or where the facts tends to diminishes the risk, or where the facts are superfluous in nature. In all these cases, my friends, we shall see that the insured is not required to disclose upon with, is not required to make upon with. I like to go with one more case here and conclude my discussion on this, that is in Glickman versus Lankensiu and General Insurance Company Limited. In fact, here in this case, Glickman made a proposal for his house to be protected by fire. And one question that there was in the proposal was that whether the Glickman, that is the policy holder who is willing to take the policy, was being affected by any of such instances for his house. That was one question which was there in the proposal, and that was not being answered by the Glickman. So when it was not answered, it was given to the company. The company also accepted, and the policy was being given to him. After having given the policy, there was a fire breakage in the house, and as a result, there was a huge loss to the house of Glickman, and he claimed for the compensation. The company refused that there was no enough disclosure made by the person. So when the case was being brought before the court, the company took a plea saying that there was no enough disclosure by the insured or by the assured. And the assured has left the column blank without answering, saying that as in the previous case of 2 occasions, the proposal has refused to give an information, or because of non-disclosure of information, it was amounted to say that there was no enough disclosure, and the court said that the assured has not acted in good faith. So these circumstances would make to say that disclosure in case of insurance becomes very important, and that's what, my friends, we shall say that this acts on the ambit of utmost good faith. The word utmost is used here, that is, to the possible extent of yours, to the known fact of yours, you should be acting in good faith. It is not that contract is just, it is not just saying it is a contract of good faith, utmost good faith, to the possible extent of what you know, you should be giving out your information. So that is what it calls you with respect to that of the utmost good faith. Good faith. Thank you for this, my friends, for today's discussion. The next